As part of our role, SALRI decided to initiate a review of the role and operation of suppression orders in South Australia, and in 2024, following extensive consultation and research, SALRI released its report.
Open justice means that if one of us is prosecuted, charged and tried for a criminal offence, that trial will be heard in an open court. That is, a court open to any member of the public who wishes to come in and see it. It is only not open when the judge orders the court be closed, and that almost invariably happens if a child or other victim of a sex offence is giving evidence. But that doesn't mean what is said by that child is not available to the press or the public. In some circumstances, courts have found it necessary over a generation to suppress from publication some of what's said in court. That is often to protect the right of the accused to a fair trial, or to protect a victim of an offence, particularly a child victim, or a witness who is giving evidence about private matters.
After hundreds of submissions and regional forums, SALRI found three things. First, open justice should be the default, but it is not absolute, and there are instances where publicity would derail a trial or endanger someone, and in these cases a tailored response is appropriate. Second, the current test is broadly sound, but it is both scattered and technical, so even the most seasoned reporters may struggle to find out what can be published.
Third, the internet has changed the game. Judges need explicit powers to order a website or social media platform to take down illegal posts quickly. The law must spell out who prosecutes breaches and who pays if a trial is delayed. Without these changes, the system risks looking toothless, or even worse, arbitrary.
Speak plainly. Change the terminology from suppression order to non-publication order in all SA statutes and court forms. This removes the cover-up stigma connected with these orders and tells the public exactly what these orders do. Prevents publication and nothing more. Give judges modern tools. Amend the Evidence Act to allow courts to make fast online takedown orders to remove harmful material before it goes viral, and broaden the definition of publish to cover new media. Shine a brighter light. Create a courts-run media accreditation program and update the public suppression order register so that journalists, whether in Adelaide or Port Augusta, can instantly check what's restricted and why. That transparency should curb accidental breaches and public scepticism. Protect the vulnerable and the budget. Strengthen automatic protections for children and cultural secrets, and allow judges to issue costs orders against anyone who illegally publishes material that leads to a trial being adjourned, ensuring both the public purse and victims aren't paying for reckless clicks. Together, these changes keep SA's courts opened by default, close them only when justice demands it, and arm the law with clear, enforceable rules that make sense in a hyper-connected world. If you would like to read our full report or find out more about SALRI's work in general, head to our website.